The following is a presentation of Project Independence and WCWP. Project Independence is the Aging in Place initiative of the town of North Hempstead. We provide programs and services designed to assist and support the older town residents who wish to remain in their homes as they age. If we don't currently provide a service, we will try and connect you to that service. Call 311 or 869-6311 to get more information or receive services.
Welcome to Project Independence and You.
Welcome to Project Independence on Community Talk Radio, 88.1 FM and WCWP.org. I'm your host, Rebecca Miller, along with our co-host, Otto Lohse. How are you, Otto?
Good morning, Rebecca.
Always
nice day.
Nice day, it sure is. Let's not talk about tomorrow, but today looks very nice. And of course, Christina Liu, who is this radio show producer and brings together the show every single week, now going into our 11th year. So we'll be talking a lot with Christina in Talk of the Town segment, but right now our guest is Ron Fatoullah. So Ron, it's so great to have you. You are an elder law attorney and a great longtime friend of Project Independence. I know I've worked with you and we've done programming going back to almost 2007. So thank you so much. You've been on the show a lot and always such good information.
You're more than welcome, and it's great being here again. And there's so much going on, and I'm happy to share the information that I have.
Great. Otto and I and Christina, we were talking about, there's so much going on. So we definitely want to get to the governor's updates and all the information with Medicaid that, we generally do. But I thought it would be interesting to talk to you about the fact of the matter is, 10,000 people a day are turning 65. And out of those 10,000, I think 9,999 haven't planned. So of course, we talk about this a lot. People just don't plan. But if there is like soup to nuts, if you are a younger senior, because that's really when I think things start kicking in, even though they should kick in, decade before. But you're talking to someone who hasn't really planned, they're facing retirement, 65. What are the essential things that they should start with right off the bat?
Sure. Thanks, Rebecca. And look, going to an elder law or estate planning attorney is not like going to the dentist. It's really not so bad. We don't drill, we just plan. We're going to make your life easier. It's not difficult to do. Some people get superstitious. Oh, if I'm going to do this planning, something's going to happen. It's just not the way it works. That's not going to happen. One has nothing to do with the other. But there are core documents that everyone should have, and it starts off with a last will and testament, core documents, powers of attorneys. We have a brand new power of attorney law about 6 months ago, and we're still feeling our way through it, which is, I think it's a good thing. It's an improvement. Healthcare proxy, a very simple document. God forbid if you can't make your own healthcare decisions, who's going to make them? A living will, and most individuals would benefit from a living trust. Not all, but most. So you want to go in, everyone should do planning. You want to plan for potential long-term care. You want to do estate planning. You want to make sure that your assets eventually go to the right individuals. You want to do tax planning. It just makes good sense.
Right. So maybe starting off with a living trust, people wouldn't be as superstitious because that implies that it's while the person is still around. So this would be an interesting document. Could you talk a little bit about what exactly a living trust is? Sure.
Let's start off with a definition and the very basics of different types of living trusts. So a living trust is an entity that's created by an agreement. It could be a corporation. Corporation could hold assets. Well, a trust is an entity that's created that holds assets and the assets are managed in accordance with the terms of the trust. Now, we set up the trust for various reasons, but with this entity is set up, sometimes we need a separate tax ID number. Most of the time, you could just use your own social security number, in creating an account, let's say at a bank, under the name of the trust. But the trust is simply an entity. Now, there are three main parties to this trust. One is the individual that creates the trust. That individual is called the creator. Wonder how they got that name. The creator, the grantor, Grantor, or settlor, Settlor. So that individual creates the trust and typically funds the trust. Might put your home in the trust, might be a life insurance policy, a bank account, a brokerage account, etc. So the grantor, settlor, creator funds this trust. The trust is managed by the second individual called the trustee. There can be one trustee, there could be many trustees, co-trustees, and they manage the assets in the trust in accordance with the terms that are set up in the trust. Now, we would draft the trust agreement for a specific purpose. Are we trying to preserve assets for Medicaid? Are we trying to save on estate taxes, capital gains taxes, etc.? So every trust has a different purpose, maybe just to avoid probate. The third party to a trust is what you and I would want to be, is a beneficiary. Mm-hmm. That beneficiary could be, for example, a lifetime beneficiary. You get income for life or a certain amount for life, and then upon death, the assets go to other beneficiaries. So those are called remainder men or remainder people beneficiaries. The term has changed since I went to law school. So it's remainder persons, I guess, at this point. But the remainder beneficiaries might be the beneficiaries after death. So those are the parties to the trust. Now, you have two different basic types of trusts. You can have a trust that goes within your will. That trust is called a testamentary trust. It's a trust that you create in your will, but won't come to life until after the will is probated. So let's say I do a will and I provide for 3 children, child A outright, child B outright, but child C is a spendthrift. She can't hold on to money, so I will not give her money outright. It'll go into this trust under the will, and the money will be doled out to her for her own protection. That trust is called a testamentary trust because it's in a will. The other basic type of trust is what you mentioned, Rebecca, is the living trust. That's a trust, and you're correct, it's signed while you're living. You don't have to wait till probate for it to be effective. It's good right here, right now, when you sign it. That's the living trust. And there are, just another couple of seconds, 2 different basic types of trusts that are signed while you're living. One is a revocable living trust that you could revoke and change at any time. And the other is an irrevocable trust that is, you can revoke, but it's much more difficult to revoke. A testamentary trust in the will is, by definition, an irrevocable trust after probate. The revocable trust is revocable all the time. An irrevocable trust, it takes some effort and certain parties to be able to revoke that trust. And the various reasons why we would create a revocable trust and why we would create an irrevocable trust. So certain trusts do certain things, and we have to draft accordingly.
Just a basic concept. Basically, as I understand it, what you're doing is whatever the assets are, you're transferring them out of your name into the name of the trust. So the trust is now the owner of that asset. Um, and as I understand it, like if you have a life insurance or you have a a, a brokerage account or whatever, you
Mhm.
can set up beneficiaries to some of those.
Yes.
So would you transfer that type of an asset that has beneficiaries already established into a trust?
It depends on the circumstances. So let's say someone would want to go on Medicaid and their assets are over the level, and they do have a beneficiary on that account. We still may want to transfer that asset into a Medicaid asset protection trust. Or if an individual has lots and lots of assets and we're doing estate planning, because the New York State estate tax level just went up to a little over 6 million, and the federal level is over 12 million, but it's going to be halved in a couple of years. So when we deal with assets with clients with lots of assets, we may want to do estate planning. And even though they may have beneficiaries on an account, we may want to maneuver that into a trust for certain reasons to get the assets out of their name now for tax purposes. See, sometimes we want to get assets out for Medicaid purposes, sometimes out for tax purposes.
Mhm.
Many times people want to use a trust to avoid probate. So Otto, you bring up a very good question. If you have a beneficiary on an account, automatically that avoids probate, because when you pass away, the assets will go to the beneficiaries. When assets go into a trust, that also avoids probate, but it also does many other things. So yes, it's a good idea to have beneficiaries on assets sometimes, not always. Yes, it does avoid probate, but there are many other reasons to transfer assets into trusts. And you certainly don't want to have a beneficiary designation. For example, let's say you want to name your grandchildren, but you don't want them to get all of this money in that account at age 18. So you'd want to put it into your living trust so that maybe they'll get it at age 25, sometimes even 30. This week, I spoke to a client who wanted all assets to go to the grandchildren, actually, at age 55. And I said, whoa, that is very, very late. Usually, unless there's an issue. I said, is there a special need? No. Are they bad kids, on drugs? No, they're great kids. We talked her down. It's her decision, but after discussing it for a long time, she's down to about age 30, 35. She's considering that.
Many of the conversations I have with people in my bracket, actually, when you talk about the essentials of planning, trust seems to be like a number one item, mainly because a lot of people are confused by it. And the other part of it is that a lot of people are in the same category as I personally would be in, frankly. All of my assets, basically, for the most part, except my house, have beneficiaries.
Okay.
So the only thing left, as I see it, that a lot of people are in that same category would wind up putting into a trust is the house. And then you ask yourself, okay, so we're going to avoid probate. I'm not worrying about the $6 million part of it because that's not where a lot of the people fit.
Most aren't.
Yeah, right. So, if it's just down to the house, like you said earlier, is it for everybody? What's your view on if it's just down to the house kind of thing?
Very good question, Otto. It depends on the circumstances. So let's say, look, the homes in the homes in North Hempstead are quite expensive. Even a modest looking home, when I have a couple of friends upstate, and I said, here's a home for sale. I live in Great Neck, and here's a home for sale. And he said, "Oh, good. How much?" And I said, it's $1 million, modestly priced today. So let me give you an example. It depends on the circumstances. Let's say you want to do Medicaid planning. If the home is in your name, you can have equity in that home and still go on Medicaid if the equity value is $955,000 or less. But it doesn't mean that Medicaid won't recover against that home. By putting the home into the trust, we get it out of the individual's name in case the value creeps up over that 955 level. And that went up about $60,000 recently. So it's now up to 955,000, but it'll avoid Medicaid recovery and avoid, sorry, not avoid, but enabling the individual to go on Medicaid if the value creeps up to 955,000. And that's one reason. The other reason is, and you just said it, you can't put a beneficiary on a home. Or a co-op or a condominium. So it will avoid probate for that asset.
Okay, good points.
Yeah.
Another one that comes up is there are some bank accounts that people have where you can get payable on death, and then there are others where you can't. How do you protect an account that you can't if you can't put beneficiaries on it? That'd be
yeah, look, if that account is in a trust, we're set because the trust will determine who the beneficiaries are. And again, beneficiaries in a trust, whether that trust is in a will or a living trust, can go outright or into a further trust. So, you can control, people say, oh, you can't control from the grave. Well, I respectfully disagree. You can, with a further trust, you can control. Like my client wanted to control for 55 years after she died, which I thought was crazy, but you can control, from the grave. So, if you want to have control like that, you would want to put that account into a trust. Or there are other reasons like tax planning or estate tax planning or Medicaid planning. If, for example, an individual has modest assets, 100,000, 200,000, and they just want to avoid probate, there is absolutely nothing wrong when they're in a trusting family, they want to give their assets directly to the children, no contest on anything, name beneficiaries. It's a simple, easy way to do it.
Okay, actually, we have to take a quick break. We'll be continuing shortly with Ron Fatoullah, our guest. You're listening to Project Independence in You on 88.1 FM and WCWP.org. We will be right back.
Take WCWP with you wherever you go with the WCWP app. Listen live 24/7 to all of our streams, all from one app. Plus, call the studios directly from the app and visit our social media. Download the app through the iOS App Store on Apple devices or the Google Play Store on Android by searching WCWP Radio, or visit WCWP.org for links. The WCWP app, available now on iOS and Android devices.
Welcome back to Project Independence in You, Community Talk Radio on 88.1 FM and WCWP.org. Your host for today, Rebecca Miller, along with our co-host, Otto Lohse, and of course, our wonderful radio show producer, Christina Liu. Our guest today is Ron Fatoullah. Ron, as I said earlier, is a great friend of Project Independence, and you've been really on board with us ever since we started many, many years, over 15 years now. So welcome back, and thank you again. This information is just, I have more notes than I think I've had with any other guest. So we, before over break, I know Otto had something that he wanted.
Yeah, well, one of the other topics in the course of conversation about living trust is cost, all right? People bring numbers up to me. I've not really looked into it, but they bring numbers up. They say like $7,500, whatever. And then I'm thinking about that and I'm saying, I could visualize some people having lots of assets to transfer. You know, they got big assets. And then there are a lot of other people who only have a few accounts to worry about and a house. So does the cost of a living trust vary by the complexity of the assets that have to be transferred into the
It
trust?
does. Otto, it's good to hear, but we don't charge $7,500 for our typical trust or Medicaid trust. The cost typically ranges anywhere from around close to $4,000 to close to $5,000 for, I would say, 95% of the trusts that we do. However, if, for example, a client comes in like they did a week ago with close to $100 million, it's very complex. That's just a totally different story. You know, the trusts tend to be very complex and the planning complex, and lots of other individuals have to be retained as well as, you know, there are appraisers and trying to get discounts, et cetera. But typically, it's typically not over $5,000. And that's the cost for a lifetime, unless that trust has to be amended. And that's only a few $100s and happens fairly infrequently because within the trust, we try to think about contingencies. For example, even in the Medicaid irrevocable asset protection trust, you know, a client comes in and says, you know, my son has been awful to me. I want to reduce the amount that he gets. Well, within that trust, we can put provisions called powers of appointment. And they could change. They could say that the child gets zero or half or anything. You can have that during lifetime within that ability within the trust to direct who gets what and how much and what percentage. And that's still the irrevocable trust, and Medicaid approves it. So it's not a big fee, considering that even if it's just the home, if we're protecting a home valued at $500,000 or $700,000, and it costs a couple of thousand to do, I think that's a pretty good return on your money. And you typically don't have to change that trust because of the flexibility that we put into the trust, even if it's an irrevocable trust. And again, I think I said it on the last show, but I have to say it again. You can revoke a revocable trust, and you can revoke an irrevocable trust. I know I just said it, but you can revoke an irrevocable trust. And the way we draft our irrevocable trusts, we make them quite simple to revoke. I know it sounds like the terms just don't make sense. Irrevocable means irrevocable, but you know.
To be Medicaid protected, does it have to be irrevocable?
Yes, if you had total control of those assets, Medicaid will say, like you do it in a revocable trust, Medicaid will say it's your money. You could revoke it, you could amend it, you could just pull the money out anytime you want. Medicaid will say, you have $500,000 in a revocable trust, you have $500,000 from Medicaid, and it's there, and you can't go on Medicaid because the asset level currently is $16,800.
Ron, I'm wondering if we could back up a little bit, because you're mentioning a lot about Medicaid, which we're in the biz, we understand, but there are people that are 60, 65 and probably a little bit confused by how much you're referring to Medicaid, and, you know, based on them turning 65 just newly probably on Medicare, they may be a little bit confused how Medicaid plays a role as we get older and why one would opt in or how they would. So if you could just give a little kind of foundation as to Medicaid and retirement.
Sure. Medicaid and retirement. The governor has this proposal in her budget to eliminate an asset test for Medicaid. We all believe, we don't know for sure because the budget hasn't been signed yet, but that elimination of the asset test will be for individuals 65 and older with limited income. But we believe that the governor will eliminate the asset test for that. So if you're over 65 and you need health insurance and you have limited income, you can have a home valued at, $1 million or whatever it is. It looks like that's the case, or at least 955,000, and go on Medicaid. That's Medicaid insurance, like health insurance. So that's one thing. But as we age, we all know that there's a very good chance at some point we're going to need some help, maybe at home, maybe in a nursing home in the future. Those costs are extremely expensive. For home care, the average cost, even just for a custodial person, just an attendant to help you out, not a nurse, when, with an agency is about $30 to $35 an hour. Just do the math. 10 times, let's say you need 10 hours times 30 or 35, 300, 350 a day times 365. That's a huge number for anybody, anyone, anywhere. And for us, in Nassau County, it's a huge number because, to be quite honest, we're saddled with high taxes with our houses and condos, et cetera. Taxes are not cheap here, and the cost of living isn't cheap. I love Long Island. I love living in the town of North Hempstead. We have the best beach. Everything is just wonderful. I love it here, but it's expensive. Anyway, so we can protect assets for the home care. As I said, it's expensive. And nursing home care, people think, well, it could be expensive. It might be $5,000 a month. Try up to $20,000 a month. In Nassau County. New York City is the same. Suffolk County is the same. In fact, Long Island, Nassau and Suffolk counties have the highest cost of long-term care in New York State. Right here in Nassau County, it's the highest. And New York State knows it because they gave us regional rates. The average cost of care per month in Nassau, and they include Suffolk County, are the highest in the state. So since the cost of home care is so high, the cost of nursing home care is so high, we want to make sure that you'll be in a position to not lose all your assets and still get the care that you may need in the future. So let's backtrack. How do you pay for this care if, God forbid, you need it? Well, if you have millions of dollars, you could self-insure. You don't need Medicaid or anything else. You'll just pay for it. Long-term care insurance is a great option, but virtually all of the players are out of the market. There's only one or two companies that still write long-term care policies. The policies are getting more expensive. There's not much competition, and insurance companies are raising rates on individuals that have had their policies for a long time. And unfortunately, many of my clients many of my clients aren't able to afford the increases. So I like long-term care insurance, but there's a very large insurance company that raised my rate not so long ago, not 10% or 20%, 100%, double. And they got the approval from the insurance department because they didn't have enough money in reserve. They can't just do it on their own, but they didn't think ahead. They didn't have the seichel, if you know what I mean, as sometimes we say in the town of North Hempstead. They didn't have the foresight to keep enough in reserve. So, we're all suffering. So I love the concept. And I grit my teeth every November when I write that large check. But long-term care insurance is great, but it's expensive. And most people don't have it because it's expensive. So
I have it.
And I have it, but God, my policy just doubled. And then they added another 10 to 20% on top of that afterwards, believe it or not, after doubling it.
Oh my gosh.
Yeah. Oh my gosh.
I'm in the same boat. I mean, they just keep doing that. And the amount you get back per day, I've been paying, 20 years, 25 years.
Yeah.
But they keep putting a lid on it. So I don't take the increase anymore either.
Yeah, yeah.
Right.
So
So
either
you're
you
going to
pay
get,
more,
you get
you-
reimbursed for 15-year ago standards, basically.
that's right. That's
Yeah.
right. So they didn't have the foresight to really plan it out the right way and price it right. So if you don't have millions, and you don't have, or you had to drop long-term care insurance, or you're too sick to get it, and it is very expensive, well, those are two ways. Medicare, so many people think Medicare is going to cover long-term care. It
Mhm.
just doesn't. It covers a little nursing home care. It could cover a little home care, but you have to have a skilled care need, the need for physical therapy, occupational therapy, things like that, et cetera. But it's not a long-term solution. So the only way to pay for long-term care, really, for most people, is either they shell it out from their pockets. Do the math: 20,000 a month times 12. Unfortunately, we could do that math pretty simply. It's about $250,000 a year if you need nursing home care. So by doing Medicaid planning, we could preserve your assets so that you, whether you're the well spouse or the individual that might need the care, you could live a more dignified life. Many times when I lecture, some people shake their heads and, you're trying to get millionaires on Medicaid. I'm just trying to have the individuals that come into my office be able to hold their heads up high, get the care they need, and don't have to worry about becoming impoverished. And that's it.
One of the biggest assets I think everybody in Long Island has, if you're fortunate enough to have a house, is the house. I
Yeah.
think the second thing is IRA money,
Mhm.
that people built up over years. Where does IRA stack up as far as Medicaid is concerned?
It's funny you mention that because I actually changed the law on IRAs and Medicaid about 15 years ago with a case client in Queens. At the time, the IRAs were available. The New York City Medicaid said, and I came up with a concept based on the Social Security law. And New York City says, as every county said, IRAs are not exempt. Your client could just take the money out of the bank. I said, no, 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 no. We're SSI-related Medicaid in New York State. And the SSI rules say, under the program operation manual, the POMs, say that if you have a retirement account in payout status, it's exempt for SSI. So I took that to New York City. They said, no, no, no. And I had a client who was willing to have me argue this. And I argued it, and we won, without even going to a lawsuit, just based on briefs back and forth. And so IRAs, retirement accounts, even Roth retirement accounts that you could take out without paying any taxes are exempt for Medicaid purposes as long as they are in payout status. Now, Nassau County, New York City lets us use the IRA life tables, to figure out what's payout status. Nassau County wants us to use a little bit more stringent of life expectancy tables. But look, the average cost of it, the average cost of a nursing home is close to $250,000 a year, as we just went through. But the average time spent in a nursing home is only about 2.4 years. Mm-hmm. Yeah, we've had cases where someone has been in there 15 years, but it's really that's an outlier. Typically a couple of years. Nobody goes into a nursing home because they want to. It's because they have to. So the rule now is throughout New York State. Suffolk County held out till almost the end, but all counties, New York State says that an IRA in payout status is exempt, but they are going to budget the distributions that you have to take. So it has to be in payout status to be exempt, but the income that you take every year is budgeted as extra income. But if you think about it, if the average stay in a nursing home is 2.4 years, then So you're losing 2.4 years of your RMDs or distributions from your IRAs, and then they're exempt. And then there's no Medicaid recovery by simply putting beneficiary designations in that IRA.
Does the pension, the New York State pension, follow those same guidelines as the IRA?
If it's a pension that you get every month while you're living, that's different. But if it's a retirement account, like for example, the teachers union, they have the TDA, and that's an annuity, but it's a retirement annuity. That's exempt. That's exempt. So if it's truly a retirement, a 403B, it's a retirement account.
Right.
That's exempt from Medicaid. As long as it's in payout status, yes, they'll budget the distributions, but it all makes sense.
How do you define payout status? You have to be 70 and a half or?
Well, yeah, now it's 72. They raised it to 72.
Right.
There's a bipartisan. Have we ever heard of that before? Well, actually, yes, we have. Just today,
while.
Right? Bipartisan bill today, which includes money for Ukraine. But there's a bipartisan bill that will raise that age to 75, we think, if the president signs it.
Okay, we actually have to take a quick break, but we'll come back to this. You're listening to Project Independence in You on 88.1 FM and WCWP.org, and we will be right back.
WCWP is your home for great music and great conversation. You'll find all that and more on WCWP.org. Listen live on the web, check out the lineup, subscribe to podcasts, and stay up to date on the latest station events. Get in touch with us and let us know if you like what you're hearing. And find out how you can support or get involved at the only community public radio station serving Nassau's North Shore. Plus, sign up to get a free bumper sticker. It's all online at WCWP.org.
And welcome back to Project Independence in You, Community Talk Radio on 88.1 FM and WCWP.org. I am Rebecca Miller, your host for today, along with co-host Otto Lohse and Christina Liu, our radio show producer, also Dan Cox, who is the director of WCWP.org, 88.1 FM, and of course, our great guest, Ron Fatoullah, who is just giving us so much information. I have more notes than I think I've taken with any other guest, just because it's really, you can't put a price on this. So thank you so much as usual. Before we went to break, we were talking about IRAs and how they fare into Medicaid and all that kind of information. So I know that Otto, you had mentioned something during the break that you wanted to continue with.
Did I mention the payout status part of it, right? Do you have to
Yes.
be, I asked the question, I thought the number was 72, and Ron gave us good information. So the question, I guess, is what is payout status?
Sure. Payout status is taking out money from that IRA over the course of your lifetime. Now, the IRS says you don't have to start doing that until age 72. There's a bipartisan bill to increase that to age 75, but it hasn't been signed yet. But what if you're 60 years old, early onset Alzheimer's? You need to go on Medicaid now, age 60, let's say, God forbid, and I hate those cases. But the IRS says you don't have to take distributions till age 72. What do? The simple answer is we could take distributions at age 60 and turn that available asset, that IRA, into an exempt asset by just simply taking distributions over the lifetime of that individual based on charts that Nassau County uses to determine this. So it's quite simple, not complicated.
These are all based on assets. And then if people have an income, is there like an income between pension and Social Security and whatever, a line that you have to be under in order to qualify for Medicaid?
Well, for Medicaid home care, the income level is $954 a month. who could do anything in Nassau County for $954 a month? Nobody. So the law does provide that the surplus or extra income in a home care case can go into a pooled income trust and can be used for rent, to pay mortgage, taxes on your home, national grid, utilities, water, sewer, everything else, cable, and you should be in good shape. So, yes.
I was just going to say, and kind of line what Otto was talking about, how on Long Island, for the most part, our homes are our biggest asset. Recently, I think it was Newsday had an article on people are, so many now people are looking for two-family homes, and that they're looking to change a lot of the rules in terms of mother-daughter or accessory apartments. And there's a real need for that because a lot of in-laws, grandparents are moving in. So that's probably going to start happening a lot more on Long Island. It's going to probably proliferate as these laws seem to be getting a little bit more lenient and letting people, at least within families, have two-family homes. How does that complicate, estates, especially if you're sharing a title or a mortgage, or, is there a good formula for setting something like that up?
Rebecca, it's a great question. And, I think there's a very simple answer to that, actually. It really doesn't matter if it's a two-family home or a four-family home. If it's your primary residence, it's your primary residence for Medicaid, number one. Mm-hmm. You have certain advantages with that. We still likely would want to protect that asset with a trust. We've been talking about Medicaid. So, for example, a Medicaid asset protection trust. And if you want to retain the income and get the net rental income, let's say in a two-family home, to help you during your lifetime, but still protect the property in that trust, you can do that. Mm-hmm. And let's say the two-family home is held by a daughter, instead of having a mother-daughter, but I did read that article in Newsday. Let's say it's a two-family home, daughter owns half, and the parents own half. So if I represent the parents, daughters could still own half outright. And the parents, well, that portion we could put into the Medicaid trust. It's as simple as that. So it's a great question, because I would think, if I didn't have my knowledge, that there would be a very complex answer to it. It's really not. If it's a two-family held by my client, I'd probably still put it in trust, but provide where that income goes. My clients could keep it and still protect that two-family home. Or if the home is held by a son or a daughter, half of the house can still be held by the child, the other half by the parent, my client.
It would seem that has to be this Medicaid trust has to be irrevocable. But
Yes.
It sounds like in a scenario like this, you have to have those little loopholes in there, because things could change in that kind of relationship.
Right.
Something happens to somebody,
yes.
Somebody gets married, or who knows what could happen.
Give me an example, Otto.
I'll give you an example. You want me to give you an example?
Oh yeah. Yeah, if you don't mind.
No.
I became the host all of a sudden.
Yeah, right.
I think I kind of understand too. Like if you're living with a parent, you're sharing a house, you're both on the title, right. And one of the the younger family can no longer afford to stay there and have to move.
Oh, okay.
Is that kind of what you're talking about, Otto?
Yeah, that's a perfect example.
That's a great, and sorry, Otto. No, sorry, Otto. I didn't quite know what you meant, but that's a great question. So, and or maybe, a little too close living for some families,
right.
Living in, within the same house. And usually my clients love it, because as they age, they love to have a child really close by. But if the child wants to sell his or her share, well, it has to be sold together as a unit. So if, let's say the parents have their share in a trust, and let's say it's the daughter that has her half owned outright by her. Now she wants to sell. If my clients want to sell as well, then the trust will sell. The trustee of the trust will sell the house along with the daughter, and maybe they'll move someplace else. Or sell the house outright to any third party, and that's perfectly fine. Or the trust, if there's other assets in the trust, can actually buy out the daughter's interest. We've seen that quite a bit. So just like any two-family home that might be held by two separate individuals, that's really the answer. What would you do? One might buy out the other. One might provide, I'm just going to rent it out. The daughter might say, Dad, you want to live here? I don't want to live here anymore. I know you don't want to sell, and I know you don't want to rent that out. You don't have the money to buy it. I'll just rent it out. I'll make sure we handpick great tenants. I'll rent it out. I'll get some income, and I'm going to use that income to help me out with the next house I'm going to be buying. So there are a lot of permutations, but we get the same issues, just as, any property might be held by two individuals. If one wants to sell and one doesn't, what do? It's
Right.
either we all sell, one party buys out the other, or half of it could be rented for a period of time, etc.
Would that be
I'm
complicated? I'm sorry, but would that be complicated by, can you put only half of the house in a trust? In other words, this trust is the daughter's trust, and she
Right.
puts her half of the house in the trust. The other half is not in a trust.
That's correct. That's correct. So you can't, it's not like, it's a one half of an undivided interest. So it's not as if, unless you condo it out, which nobody will do on a two-family home, it's a half of an undivided interest. So you can't say, this half of the house, the deed is for this half of the house, and there's another deed for the other half, unless you actually condo out the two halves, which is very infrequent in just a two-family home.
Right.
So the trust will hold a 50% interest in the whole home. So you're right, it does create some issues. So all of the owners either sell it, one buys out the other, or the daughter could rent out.
I am actually in that situation. I mean, thankfully everything is fine. But, because of that article, it kind of made me think a lot. This is definitely something you need to think about, because I think what happens if younger family decides to move out, older parents buy out the person, I think the house, my understanding, then becomes part of the whole estate. So it's no
Correct.
longer, 50% the daughters, and, it's like becomes part of the whole estate. So it's complicated, and it's really good to figure this all out before you jump in, because it's complicated. It's very complicated, especially there's divorce, could be a divorce involved. There could be, all kinds of things that could happen. So, I think that this whole, for us anyway, on Long Island, it's a newer concept. I know in other parts of the country, there's a lot more ease with house sharing and that kind of a thing. But here, especially on Long Island, it's very complicated. So, yeah.
We had one instance. It's a very interesting example where that was the situation. The daughter had, for her job, had to move away from New York, but my client wanted to do Medicaid planning, but the home would be exempt from Medicaid as a primary residence, and it was under that level now, $955,000. My client had, some modest money, but enough to buy out the daughter. So my client took his available money from Medicaid, bought out the daughter who co-owned the house. That was not a gift, which, creates a penalty period. Now he's in a house that's exempt from Medicaid. So it was a win-win. the exact example that we were talking about.
Okay.
Yeah.
Very.
Now, another one that comes up in this kind of thinking, well, let's say a daughter or a son is living with parents in their home, and it's not really a two-family, but
Mhm.
they're living there, and now something happens, and the mother, maybe she's the only one left, has to go to a nursing home or whatever, and now there are other siblings involved, so now the remaining sibling that's in the house that's been taken care of, the parents for 15 years or whatever, pick a number. I've witnessed that kind of thing cause family problems. And what's the legal way you might handle that?
Okay. Well, the legal way is actually, Otto, quite thorny, because you bring up an excellent point. There's an exception to the Medicaid transfer rules. When you gift assets, Medicaid wants to penalize you in the future. They're just doing it for Medicaid nursing home care now. They will start to do that for Medicaid home care. It looks like July 1. We'll see. They pushed out this date quite a bit. But if that daughter was living in mom's home for more than 2 years, it's a free transfer. Medicaid will see it. Oh, I gifted this $1 million home to this daughter that's living there for 2 years. Medicaid will see it, and it's a free transfer. They're going to say it's not a transfer because it was gifted to an adult caregiver child. That's an exception.
Is that a look back? Is there like look back involved, or that's forever?
That's forever. Medicaid will look back 5 years for nursing home care. They're going to see that. They'll say, okay, that's a gift. And we'll say, yes, it is a gift, but it's an exempt gift. It's an exempt transfer because it went to an adult child who was a caregiver for at least 2 years prior to the time you went into a nursing home. Mm-hmm. But it's only free if it goes to the daughter who is living there. So Otto, look at the complexity of the question you asked. Now, if the home, the major asset of this woman, let's assume, goes to one child, what about the other children? So some of my colleagues have actually created agreements saying, all right, okay, if you transfer to daughter, but daughter's going to have to even things out afterwards. And I was a little concerned about that. So I went to Medicaid because I wanted to see, what do you think about this? And they said unequivocally that it's not for Medicaid purposes. Even though you transfer it to that daughter, if she then just evens it out because there's a preset agreement, then it's like transferring it to all the children together. So they made it very, very clear. So if we do something like that, the clients have to know if the daughter does, quote unquote, the right thing and evens things out afterwards, because that's what mom wants. And our mom could go into a nursing home, and it's not going to cost anything. Great. But if she doesn't, if you put strings on that transfer, then Medicaid will say it's not a transfer to that adult caregiver child who's lived there for 2 years. So it brings up a lot of issues. There are a lot of issues that we've had over the years, and other attorneys have as well, where the daughters might say, okay, I'll split it, and then has second thoughts because a spouse may be whispering in her ear, and etc. And that is a big, big issue. So I think, in my opinion, the way I've been doing it, we have family conversations. I want everyone, if the parents, or mom in this case, will agree to this, we have everyone sit down in our conference room or on Zoom like this, and we go through it. This is what the law is. We could get you on Medicaid. It'll cost you virtually nothing, not the $250,000 a year, but these are the circumstances. And we work with them and we plan it out. There are lots of different ways. And I will just say basically that even if you don't do the transfer, a home in your name is exempt if you have an intent to return back to that home, if it's under the 955.
Thank you so much, Ron. Such great information and so timely. You know, we really appreciate, I'm sure you'll be back. I know you'll be back. We appreciate your time. I know it's so valuable. And
thank you.
we have to go to a break. You're listening to Project Independence in You on 88.1 FM and WCWP.org.